answering the question of when do you need an LLC operating agreement? So LLCs can be formed fairly quickly with the proper state agency of whatever state you want to form it in, whether that's here in Arizona, Wyoming, or any other state. And you basically fill out articles of organization and you submit them and you file them with the state, and then they stamp, they approve, they say, okay, now you have an official LLC. But behind the scenes, there's a document that is called an operating agreement, which basically controls the operations of the LLC. It also provides for information regarding ownership of the LLC, who owns what percentage of the LLC. It provides for management of the LLC, who are the managers, who has the ability to run the LLC. It basically governs the full operations of the LLC, but you do not need an LLC operating agreement to create an LLC. You can form an LLC and it will be validly formed with the state that, it's formed in without an operating agreement. So the question is, well, then why do we need an operating agreement? And there's, what I found is really two main situations for an operating agreement. There's others as well, but where my clients tend to miss the boat when they come to us and they're, trying to close on real estate, or they are trying to, organize or set up their organizational structure. And they've already started a little bit by forming some LLCs. The two areas that they miss the boat on and they don't have operating agreements for are when they form the LLC in an anonymity state. So that would be in Wyoming, Delaware, and there's a few other states, New Mexico. They go and they form it, but they don't have an operating agreement, and that's a major problem. And the reason why it's a major problem is when you're forming in an anonymity state, you are basically submitting articles of organization that simply state the name of the company that you're forming, as well as the registered agent of that company in the state where you're forming it. The articles of organization do not have anything regarding the owners of the LLC, or what we call members, the managers of the LLC. It's void of all of that information. So the only way when you form in an anonymity state that you know who owns the LLC or who manages the LLC is to have an operating agreement. And you must have that operating agreement in place to operate an LLC that's formed in an anonymity state. And the reason for that is because you need the protection of the corporate veil. If you're out there transacting on behalf of an LLC that doesn't have any members because you don't have an operating agreement, or doesn't have any managers that can act on behalf of the LLC, then basically you and the LLC are one. You haven't created that corporate veil that the operating agreement would provide to protect you and keep separate the LLC from the individuals who, own it and manage it and operate it. And that's what that operating agreement does. It says, okay, this individual has the authority to act on behalf of the LLC. So when they go and sign something on behalf of the LLC, they are doing it under the power given to them by the operating agreement. But if you don't have an operating agreement, then arguably they are executing contracts and loans and other documents, basically in their individual capacity or on behalf of an LLC that really doesn't even truly exist, because the operating agreement, there is no operating agreement defining who those members and managers are. So that's one area. The second area that is problematic that we see is when you have multiple members who have different ownership percentages. So for example, one member is going to own 70% of the LLC and the other member is going to own 30%, or maybe you have three members and one member is going to own 60% and the other two members are each going to own 20%, or, that type of thing. It's not going to be 1/3, 1/3, 1/3, or it's not going to be 50-50. It's a different percentage of ownership. And so, they go and they form in a state like Arizona, which is not an anonymity state. So when they fill out the articles of organization, they list all of the members, all of the owners of the LLC on there. Well, the default or the presumption is that each owner has an equal share in the ownership of the LLC. So, if there's 3 owners, then each will be deemed to have a 1/3 interest in the LLC. If there's 2 owners, they'll be deemed to have 50/50 ownership. And then they go and they operate without an operating agreement. They start paying distributions based upon, a handshake that they have saying, oh, well, you have a 60% interest and I have a 40% interest. And they go and they operate that way. But that's problematic because that's not what the default is. That's not what the state recognizes as the ownership. The only way to change that default provision within state law is to have an operating agreement that defines and overrides that state presumption of an equal share of ownership amongst the members. So if you have multiple members of an LLC that are going to have differing percentage of ownership, then you must have an operating agreement that defines that. So when you need an operating agreement is twofold. There could be, once again, other times, but it's twofold. So first, when you form in an anonymity state, and then second, when the members have differing ownership percentages.